Justice Thomas. Justice Alito.
In determining whether there was clear notice, what is the relevant point in time?
So I think it would be, what is the notice as provided by the statute? In Medina, I think it was footnote 8. The court said we care about notice as provided by Congress.
No,
so
what date? What is the date?
So when RLUIPA was enacted in 2000. And we care about
It's not the time. It's not the point at which the state accepts the money.
Yes, but I think so. So yes, we care about the state's notice at the time they accepted the funds.
And
but
what is the relevant date there?
So
in this case,
RLUIPA is tied to all sorts of federal funding, and so I don't have a specific date on which they accepted funds, but I imagine they're continually accepting federal funds. You can go to usaspending.gov to see the different funds that they receive from the government.
Was it clear before Tanzan?
Yes, I absolutely do think it was clear, because Tanzan is illustrative. I think Tanzan is helpful for us because it shows why the textual analysis comes out the way it does. I don't think it was necessary.
Even though all the courts of appeals had gone the other way, and even without Tanzan, you think it was clear?
I would say so, Justice Alito, and here's what I would say. I mean, in talking about the courts of appeals decisions, yes, they've all gone the other way. I agree with Petitioner. Not all of them said that the statute wasn't clear. I think that really there's no sort of how lopsided is the circuit split rule. It's odd to think that at time zero, a statute could not provide clear notice, or could provide clear notice, but then at time one, when all of the circuits have gone the other way, it doesn't provide clear notice. There's just no administrable way to administer that rule. And
well, Tanzan was decided, I think, 18 days before the event in question here, and maybe General Aguinaga could answer the question, but if funds were not received after that date, doesn't that make it more difficult?
I don't think so, Your Honor. I think that timing is right from what I understand the allegations to be in the complaint. But again, I don't think the argument depends on Tanzan. The notice that we care about is the notice as provided by Congress, and text is the only reliable indicator of meaning. The other thing I'll say is sort of just as a basic principle, when Tanzan interpreted RFRA to make clear that individual capacity damages are available under RLUIPA 2, that's not just what RLUIPA meant post-Tanzan. That's what RLUIPA has always meant. That's Rivers versus Roadway Express.
I understand the point. Could you